All right. So civil litigation versus arbitration versus mediation, which is better for you? And again, I'm going to assume sort of an 8th grade education for everybody involved and remind you of your civics class from junior high school. This will be a refresher, and some of this will come back, and some of this hopefully will be new. Charles, I've heard dispute resolution. Heard dispute resolution is my business name, and some credentials are among various credentials are shown here. Okay, so civil litigation or arbitration or mediation, which is better? You'll find, and I'll do a spoiler alert, the answer is it depends, and we'll go through and figure out why. We'll talk about the difference between civil litigation, arbitration, and mediation. What are the benefits and detriments of each? And when do you decide which one you want? First option we'll talk about, which is the one that most people are most familiar with, is civil litigation. I say civil on purpose because it's the way lawsuits are pursued in the United States and really most Western companies. A lawsuit is filed. It can be filed either in state or federal court. It is a civil suit between individual parties or companies or corporations or associations, what have you. It is not a criminal case. It is a civil case. So what I'm talking about today is distinct from if a person is arrested and charged with crime and the state prosecutor or the district attorney or whoever is bringing that case, that is a criminal case. We're not talking about that today. We're talking about civil litigation, litigation between private parties. Okay, so civil litigation, in a typical lawsuit, the rules and the procedures that apply are determined by the court. This is true whether you're state or federal court. It's true whether you're here in Texas or any of the other states. The rules and the procedures are determined and interpreted and applied by the court, and that's important for reasons we'll talk about in a minute. In civil litigation, and by the way, this outline is set up to compare the same characteristics between the three options. In civil litigation, who is it who's paying for the judge, the jury, the courtroom, the staff, etc.? And the answer is everybody. We all do, from taxes. But critically for this analysis, you don't have to pay any more to try your case at the courthouse, although there are some ancillary charges for filing pleadings, etc. If it is a jury trial, it's the jury that will be deciding the facts of the case, in other words, what the facts are, who wins, plaintiff or defendant, and what the damages, if any, are. It's the jury who determines that if it is a jury trial. That's critically important. If the trial is to the court, in other words, a bench trial, which is the opposite of a jury trial, then it's the judge, it's the court who decides these things as well. So big difference between a jury trial and a bench trial. And so as you're considering litigation, always ask yourself, are we talking to the jury who will be deciding, or are we talking to the judge? Sometimes called talking to the bench. If it's a jury trial, strategy, communication, persuasion, story, critically important. The KISS, keep it simple, silly, applies really in all litigation, but particularly to a jury. Being able to tell a story that the jury will follow and remember and understand, critically important. Being able to persuade and put it in a context that the jury finds credible, critically important, as compared to trying a case to the bench, where those factors are important, but the judge is considering what is the law, what is the controlling law that applies to these facts, are the various elements of a cause of action, have they been met, is the evidence sufficient to support a verdict one way or the other. In a jury trial, you're entitled to a jury of your peers. You all know that, but the question is always, well, who are your peers and where do they come from? You'll remember from your constitutional days, the Seventh Amendment to the U.S. Constitution guarantees the right to trial by jury, preserved to the litigants, and not to be redetermined in an appellate court. Critically important. So, who are the members of the jury? Who are these peers? Where do they come from? What do they look like? And the answer is they are citizens of the county or the jurisdiction where the jury panel is selected. Typically, these folks are identified by their voting records, by their driver's license. It's intended to be random. It's selected by computer, and there's supposed to be no rhyme or reason to it, although sometimes people wonder when they get additional jury requests to appear. So if you get a request to appear, you are part of the venire, V-E-N-I-R-E, and how do you then go from the general panel to become a member of the jury? That process is called voir dire, or voir dire if you're not from Texas. And it is a process where the lawyers question the members of the panel, the venire. They may issue written questionnaires. They question the jury panel about what their experience are, what their likes and dislikes are, whether they would be appropriate for this particular case. The lawyers can challenge parties for cause because they believe that something that the panel member has said disqualifies them from the jury. After that, each party is given some strikes that they can determine that they can use to strike certain members. And people think about jury selection, but it's really deselection. The lawyers know that the process is really intended to strike potential jury members because the parties believe that they would not be a good juror for this particular case. Discovery in civil litigation is very broad. Discovery is what the lawyers and the parties do before the case comes to trial, where they gather information from each other. They may take depositions, go through a ton of documents, do inspections, investigate, etc. Discovery is very broad in civil litigation. All relevant documents can be produced. Relevant witnesses can be deposed. There's a broad use of expert witnesses. The experts typically generate reports and are deposed and frequently provide live testimony at trial. How is a jury trial or a bench trial resolved? Well, if the judge is ruling on his or her own, then they typically rule by summary judgment, which disposes of the case early on. They can approve a settlement if a settlement's been reached between the parties. They can issue findings of fact and conclusions of law, which is a fancy way of saying the judge decides what the issues are and what the conclusions are. If it's a jury trial and the jury has entered its verdict by coming back after deliberations and advising the court what the answers to the jury questions are, the judge then enters an order accepting the decisions of the jury, and that's how the case is resolved. Everybody has heard of blind justice. This is blind justice with a blindfold on purpose, a sword of justice in one hand and the critical scales of justice in the other. The idea of blind justice is that the jurors are not being influenced by bias or prejudice. They're not influenced by things that they shouldn't be considering. They're supposed to be looking at the evidence only and determining credibility of witnesses and persuasiveness based on what they see and hear, not based on something inappropriate. Standards, there are different standards that apply. Burden of proof is frequently talked about. In jury trials, it's a preponderance of the evidence, which is typically described as 51% of the evidence, versus the greater weight and sufficiency, which, as you can imagine, is a higher standard, versus the highest standard beyond a reasonable doubt. That, you will remember, applies in a criminal case, not in a civil case. I mention it now just because you've heard of it. I'm trying to put it in context for you. So, expert witnesses, what are they for in a trial? They are supposed to help the jury understand. They're supposed to help the jury or the judge understand difficult or complex issues. What I find as a lawyer is the experts' opinions frequently are influenced by who's presenting them and who's paying for them. Not surprisingly, if both sides hire different experts, the experts likely disagree. That shouldn't come as a surprise because they wouldn't be hired as experts if they agreed on everything. And this is a rhetorical question. Do the experts really help explain, or are they part of the persuasion of a party? I think it's the latter. How are damages determined in civil litigation? Actual damages are determined by the jury based on the evidence presented. Punitive damages, which are damages intended to punish, are also determined by the jury. The purpose of punitive damages is to discourage bad behavior by that party and to send a message to other people: don't do this, we'll slap you if you do. There typically is a higher standard of proof for punitive damages, but in reality, I think it frequently may be that the jury is mad and they're trying to send a message that they're unhappy with the party's behavior. How final is a verdict in civil litigation? Any party can appeal to the Court of Appeals of the Supreme Court, ultimately here in Texas. The Supreme Court Court of Appeals are supposed to be considering controlling law and looking at sufficiency of the evidence. They are not supposed to be second-guessing the jury as the fact finder. Remember what we talked about a minute ago about the Seventh Amendment. Okay, so civil litigation is a public hearing, a public trial. Anybody can attend. The public can attend. Media can attend. The parties get to tell their story to the whole world. You all know from history and even from movies that dramatic civil trials can change or influence public opinion. There's a great value in catharsis with the parties being able to tell their story. So, first question, option number one, civil litigation. Does that sound good to you? Before you can answer that question, you probably need to consider option number two, which is arbitration. In arbitration, there is no judge. There is no jury. The arbitration is determined by one or perhaps three arbitrators who are deciding everything. They're acting as super judges. So how are arbitrators chosen? Typically, they're chosen from a panel which is approved by an association. They can be selected by a party, often in a two-party litigation or arbitration. Each party selects an arbitrator. Those two arbitrators then select the third person, and that person typically becomes the chair of the three-person panel. Arbitration rules and procedures are typically set out in advance by the arbitration body, the body that issues the arbitration procedures, usually from the American Arbitration Association or in the UK under the London Rules. Here in Texas, with a lot of cases I'm familiar with, the Society for Naval Architects and Marine Engineers. Here in Houston, the Houston Maritime Arbitration Association. All these organizations create their own rules and procedures, and depending on which organization you're arbitrating under, those rules and procedures are already set. Typically, they're always written in advance as a general rule. Arbitration, critically important, is by agreement. Typically, it is by a by a writing which is entered into between the parties in advance. In a written agreement like a purchase and sale agreement, a drilling contract, a master service agreement, etc. Caution. You may not know it, but you are already party to an arbitration provision in contracts that you probably haven't read, such as your phone agreement, your purchase and sale of stock, purchase or lease of computer equipment, of a car, of using even a parking lot. These are frequently called contracts of adhesion because you really didn't have any bargaining power. You weren't in a position to say, wait a minute, I want to negotiate that arbitration clause. And frankly, I think they are contracts of adhesion, but they are frequently upheld anyway. So caveat emptor, let the buyer beware. This is law school student, first year law school, read your contracts. How do you start an arbitration? Well, you invoke it by citing the clause in the contract that governs it. Practice tip, be sure you comply with the notice and the timeliness requirements, otherwise it can be waived. And parties typically agree that the arbitration clause is valid. And if not, the other side, you can ask them to agree, but don't hold your breath, they may not. How are arbitrators paid? We talked earlier about how judges are paid from taxes. Arbitrators are typically professional, credentially credentialed people. They're paid in advance, typically with a retainer. They draw money on draws. They have minimums. Same as for each party's lawyers. There's no difference there. How is discovery conducted in arbitration? Generally, it is more limited than in civil litigation. It's supposed to be more targeted. The depositions and the experts are supposed to be more narrowly restricted. Otherwise, they can address the same thing. Frequently, experts issue reports which are considered by the arbitrators, and frequently the experts do not testify in the arbitration hearing. How are arbitrations resolved? Well, by written award from the arbitrators. A simple award doesn't cost a lot of money because it's a finding for A or B, and whatever the award is. A more complex award is a reasoned award, which will go into some explanation. A more detailed award includes full findings, and of course it costs more money for the arbitrators to write all that. Are arbitration awards appealable? Generally, no. Look at the procedures of the relevant association, but as a general rule, they're not appealable unless the arbitrator failed to disclose a conflict of interest or just totally ignored everything going on. Very hard to get that reversed on appeal. Okay, are arbitrations confidential or is the public invited? Arbitrations typically are strictly confidential. In fact, so confidential that it's even hard to find out what the results were. And that is a problem for precedential value, because if it's done in such secrecy, nobody knows what the history of similar findings are in similar cases in the past. So far, do you like arbitration better than trial? Would your answer change if it were a bench trial or a jury trial? These are questions you want to ask yourself. But before you can answer that question, you probably need to think about option number 3, which is mediation. Mediation is a less formal process of negotiation and settlement of disputes. It can be done at any time or various times in the litigation or dispute process. It's done by agreement between the parties. It doesn't require a written agreement. You can just agree, let's go mediate and see if we can get this resolved. Confidentiality is throughout the mediation process and a very important part of it. Mediators, I'll talk about here. Mediators are not judges, although some of them used to be. Mediators are not arbitrators, although some of them may be. Mediators do not determine what the facts are. They don't act like the jury. Mediators do not determine what the law is. They don't even act like the judge. Mediators do not issue written opinions, legal opinions. They don't issue orders. They don't issue decisions. Well, what are mediators all about then? Well, good mediators listen, ask questions, test theories, ask about relative risks, help the parties identify possibilities, suggest resolutions, distinguish needs from wants. The best mediators really are settlement consultants. I'll give you an example of a curious mediation I had a few years ago. Well, I'll tell you quickly. You'll probably tell, I like mediation in the right circumstance, because a good mediator can help the parties identify options that would not be available at law or in arbitration. Let me give you an example. A year or so ago, I had a mediation over a very, very expensive AKC registered dog with impeccable credentials and history and lineage and all that kind of stuff, a very, very expensive dog. The owner of the dog lost the dog, put up signs around the neighborhood looking for the dog, ran ads in the paper, couldn't find the dog, was heartbroken. A few months later, a couple found the dog. The dog was in horrible shape, nearly dead, malnourished, covered in ticks. The people who found him spent a lot of money at the vet, saving this dog, redid their backyard to arrange for the dog to have a good place to run, blah, blah, blah. Finally, the original owner located the dog in the hands of the new owner. What the people said, the couple said, were the new owners. So they had a lawsuit. Who's entitled to the dog? Well, I was asked to mediate that case, and we went round and round and round about what the law might be and what equity might be and whether people should be reimbursed for expenses. And finally, I suggested, hey, why don't we do a child settlement agreement on this dog? And you all can take turns because you both love the dog and you want the heirs and sires of the dog, and maybe you just split it. And I thought I'd come up with a really Solomon-like solution, and they almost went for it, and then one of the parties backed out. And so it was not resolved at mediation, and they went to trial, and one of the parties was terribly disappointed. I give you that as an example of how mediators can be creative in trying to solve a problem. Okay, so what does mediation cost? Well, like arbitrators, mediators charge an hour or a daily rate, but typically it's less expensive because less time is required of the mediator than of the arbitrator. Fewer hours are involved. Discovery in mediation is typically much more limited. The parties have already gathered enough information to be able to have an informed conversation. Experts are typically not very persuasive and are not used much in mediation. I've never seen an expert come to try to provide testimony at mediation, although their reports are frequently relied upon. The goals of mediation, I've sort of mentioned earlier: identify the issues, the major facts in dispute, try to get agreement and narrowing of the issues, focus on identifying risks among the various options and ways to reach a resolution. The goal, of course, is to reach an agreement. If the parties cannot agree, it's not settled. If it is agreed, a mediated settlement agreement is prepared. The parties are to identify and sign off on the main terms. The mediated settlement agreement is signed. If any further documents are to be prepared, they're prepared. If a further dispute arises about the other documents, you typically go back to the same mediator for resolution. If the settlement is reached, the mediated settlement agreement is provided to the court, and it's over. If no settlement is reached, an impasse can be declared, and it's over, and it goes back to the court or the arbitration panel, or there can be follow-up. The mediator is supposed to only advise the court or the arbitrators that the dispute either settled or it did not settle. We talked about how mediators are who they are, how are they selected. Here are characteristics that you want in a good mediator. The major benefits to mediation is it's confidential. The mediator cannot be subpoenaed to testify. Nothing said in mediation is admissible. The settlement agreement is enforceable as a written contract. That's very helpful. And generally, they are not appealable. In other words, you make a deal, you live with it. So let's vote on chat. Which one do you like better, civil litigation, arbitration, or mediation? And I can't see the chat, so if you all will tally whatever responses you get. Spoiler alert, the answer will probably depend on the individual issues in dispute. For example, what are your goals? Do you want a quick resolution? Do you want to drag this out? Is it important that it remains secret or that there be a public hearing? Do you have confidentiality concerns? Do you want the world to see, or you want to keep only this between us? Is public opinion important, or are you trying to shy away from the public altogether? Is it important that someone has their day in court? How complex are the issues? Do you need an expert to make sense of it all? So here's a real quick summary. In civil litigation, more opportunity for discovery. The jury typically decides the facts and the damages. It is a public hearing. Everybody gets to say their piece. There are no additional costs beyond the cost of litigation itself and paying for lawyers. Frequently, and this is certainly true in the land of COVID, there's a 1 or 2 year delay. Normally, expert witnesses are typically heavily involved. It is a win-lose proposition, and it can be appealed. In arbitration, sorry?
Oh, sorry, I was going to say we've got 2 votes for mediation, and if you want the case to be tried in a court of public opinion, or you want your day in court, then a jury trial.
Interesting. Okay, good. That's interesting. In arbitration, it's private, limited discovery, limited use of experts. The arbitrators typically have experience, but they typically, I'll tell you, typically are expensive. There can also be a significant delay, hopefully not as long as it is in COVID land, but we don't know. It's also a win-lose proposition, and the parties can control to some extent how detailed the ruling is. Mediation, which as you can probably guess, is gaining more favor nationwide. And Texas, by the way, has led that effort for many years. Mediation is more flexible than the others. There are a number of options available for problem solving. It is confidential. It is private. The expert witnesses typically have less influence. If a settlement is reached, the parties write out the settlement, which is enforceable as a written contract. But the real benefit is successful mediation looks for a win-win solution, as opposed to the others, which are win-lose. And mediation is particularly beneficial when the parties are going to continue to work together, because the goal is not to burn bridges and hate each other if you have to continue to do things. I think we probably have a few minutes for questions or comments.
Okay, let's see if we've got any coming in. We've got a little bit more elaboration on our ask. Mediation for matters that can typically keep people employed and working together, like you said. You want to continue the relationship. And then arbitration is what I would choose if a situation where there is inequity between parties, but the small party wants some more rigid processes.
Okay, yeah. That's our arbitration does provide hopefully clear rules and procedures, and can be an avenue, particularly when you have unequal bargaining power. Mm-hmm. Although you can hopefully get the same benefits from trial or mediation. But yes, arbitration does provide some of that. Do we have any other questions or comments?
Not yet.
Okay. Well, as I said, this was a 10,000-foot view, and I hit the high points. The PowerPoint will be available through the NHA. A recording also, video recording, will be available through the North Houston Association. There's my information there. Easy way to contact me is my initials, CFH, Charlie Foxtrot Hotel, CFH@HERDDisputeResolution.com. There's my address, and I wish you all a safe and healthy day.